It's quite right to say that in broad terms the Equality Act 2010 consolidates existing legislation. It just brings existing legislation into the same place. But there are some notable exceptions, I think, to that, particularly perhaps starting from recruitment stage of employment. The Equality Act effectively bars employers from asking questions about individuals' medical conditions before offers of employment are made. Now that's quite an important step, I think, in terms of departing from the existing practice of employers currently. There are various changes in respect of specific discrimination protection, which are perhaps tweaks to the existing legislation, but there are some practical points as well. Those would include, for example, the need to address your day-to-day policies, perhaps to capture these provisions of the regulations in a bit more detail. And when it comes to aspects of discrimination protection, there is, I think, a slight widening of the categories of individuals who would be protected and the circumstances in which employers could, perhaps inadvertently, fall foul of the discrimination legislation. Well, there was a great deal of publicity at the point at which the legislation was implemented, but to a great extent it seemed to me that employers were confused, I think, about the nature of the legislation and really what it did and what effect it would have on them on a day-to-day basis. In terms of litigation, it's perhaps a little too early to say what impact it's had, because some of the widening of the discrimination protection that existed previously hasn't really yet come to fruition in terms of reported case law. Reported case law often takes a number of months to arise following the implementation of legislation, and the expansion of the discrimination protection under the Equality Act is perhaps, in terms of the detail rather than in terms of significant steps forward in the level of protection that employees previously had. Yes, well, one of the very interesting recent changes, which was effectively incorporated into the Equality Act at a later stage, was the repeal of the default retirement age. Now, naturally, employers, certainly in this country, have been used to retiring people at a set age, traditionally 65, although sometimes that varies slightly. That ability to retire individuals without question at that sort of default retirement age has been repealed. And so from now on, employers are going to have to justify terminating the employment of somebody who is 65 in the same way as they always have done in relation to an individual of any other age. So as I see it, that's one of the key areas, I think, where the discrimination legislation has moved on in the last 12 months and is likely to lead, I think, to more case law. I understand that the initial statistics from the Employment Tribunal Service suggest that the number of age discrimination cases has gone up slightly over the last 12 months. I think it's very difficult to justify terminating someone's employment on grounds of age, frankly, at any age. The difficulty that employers have is they have to satisfy two elements of a test. The first is that they're pursuing some legitimate aim in terminating employment at that age, and the second is that they are doing so in a manner which is proportionate. So, in a sense, they are achieving that legitimate aim in a way which is the least discriminatory way of achieving that aim. Now, naturally, employers in certain circumstances will say, well, at a particular age, physically you may be incapable of doing the job, and what I'm thinking of there is roles that require a degree of physical exertion. Well, naturally employers have a reasonable argument in certain circumstances that is the case. But the difficulty for them is that if they set a particular and arguably arbitrary age at which individuals will be considered to no longer be able to perform their job, then it's likely that a tribunal will simply respond, well, couldn't you simply have gone through some sort of performance management process? Because isn't it true that no two 65-year-olds are comparable? One may be perfectly capable of performing a particularly physical job, whereas another may be incapable of doing that job and indeed may have been incapable for a number of years. The question of whether there is potential for expansion of the grounds on which individuals are protected under discrimination legislation is a very interesting one. The Equality Act itself, in a sense, does already expand the grounds on which individuals are protected. Prior to the Equality Act, it was only in very limited circumstances that an individual could claim that they were protected from discrimination, not on grounds of their status, but on grounds of someone else's. So, for example, I couldn't claim that I'd been discriminated against on grounds of the gender of someone close to me. The Equality Act changes that position and effectively enables individuals to claim protection not just on grounds of their own status, but on the grounds of the status of other individuals. If I have caring responsibilities for an elderly individual, and I am discriminated against because of that person's age, effectively, then I can claim protection under the Equality Act in a way that I couldn't before the implementation of the Act. It's a very interesting question as to whether those grounds of protection could be expanded. The answer is I think they could, in principle. There is legislation elsewhere in the world in respect of which individuals of certain caste are protected. It is, I think, questionable at the moment whether the existing race discrimination legislation protects individuals from discrimination on grounds of caste. Well, I think as discrimination law expands, then so too does the opportunity for mediation, perhaps at an earlier stage before matters ever reach a tribunal. It's very clear from recent government announcements that their focus is on reducing the burden on the Employment Tribunal service, and indeed the current proposals to require individuals to pay a sum of money before they're able to bring a claim, and then to pay a further sum of money when the claim is listed for hearing, indicate that the focus, I think, going forward is going to be very much on mediation or indeed conciliation as a means of avoiding those hearings, and indeed on the employee's side avoiding those costs. One of the very interesting areas of the Equality Act which was not ultimately implemented by the government is a provision that potentially requires employers who employ more than 250 employees to publish information about the gender pay gap within their organisations. By that I mean the difference between what women are paid versus what men are paid. Now, the very interesting aspect of the legislation on that front is that the government has said it has no proposal to implement that provision at the moment, but it is going to wait and effectively consider whether employers are already voluntarily publishing that kind of data, and then we'll revisit the issue in, I believe, 2013 to decide whether it's appropriate to implement that provision or to provide for some other way of encouraging employers to address the gender pay gap.